Hi, my name is Garrett Sutton. I'm a corporate attorney. I wrote the book, Loopholes of Real Estate, which are strategies for protecting your real estate assets. We live in a very litigious society. Tenants, vendors, other people are suing all the time, and we want to have the right entities in place to protect you from these claims. Now, a good entity for real estate is the limited liability company, or LLC. And so we set up the LLC to hold title, for example, to your fourplex. When you go to the county recorder, it doesn't say Joe Jones as being on title. If it did, a tenant could reach not only the equity in the fourplex, but all of your personal assets. Instead, at the county recorder, it says Joe Jones LLC. That's on title to the fourplex, so that if the tenant sues, they can get what's inside the LLC, but they can't get all of your other personal assets, your bank account, the equity in your house, your other assets. So the first step is to set up an LLC to hold your real estate. The second step is we have to follow the ongoing formalities of maintaining an LLC properly. You have to pay the annual fee to the state. You've got to do those darn minutes. When you have a meeting, you have minutes of the meeting, and people say, oh, that's going to be too hard. Well, they're called minutes, not hours. It doesn't take long to prepare these minutes. Another formality is you have to have a resident agent there to accept service of process. By following these formalities, your LLC veil will be protected. If you fall down and do not follow these easy formalities, someone can pierce the corporate veil and not only get the equity in the LLC, but all of your personal assets. So we don't want that to happen. So the second step is to follow all of the corporate formalities, all right? The third step is we want to segregate assets. If we put 5 fourplexes in this LLC and a tenant fell at 1 fourplex, they could get the equity in all 5 fourplexes. So we don't want to put 5 or 10 or 20 properties in one LLC. Instead, we set up a new LLC, right, to own the next group of properties. When you cross state lines, if this LLC is set up in Ohio and you're going to set up and buy a new property in Arizona, this would be an Arizona LLC, this would be an Ohio LLC. So we segregate assets to provide greater asset protection. Again, if we have 20 properties in this one LLC, a tenant can get the equity in all 20. So let's split them out. The next step is we need a Wyoming LLC to own these property holding LLCs. We only need to set up one, but the Ohio LLC, the Arizona LLC are both owned by the Wyoming LLC. Wyoming is great. It features great asset protection. It has great charging order protection. It also features privacy. They don't list your name on the internet. So if a tenant's looking to find out who owns this property, they find out it's Wyoming, they go to the Secretary of State at Wyoming, your name does not appear anywhere. As well, Wyoming is very affordable. It's only $50 a year to the state to keep your LLC current. Again, we have to follow those corporate formalities, and in Wyoming, it's only $50 a year. Now, the last step towards real estate asset protection is to consider equity stripping. And what we mean by equity stripping is, for example, let's say this fourplex is fully paid off. This property is worth $300,000. Well, the tenant suing could get the equity in the property. What we do is set up a Wyoming LLC. Again, your name is private, and we have a line of credit from the Wyoming Equity Stripping LLC to this property here that owns the fourplex. The line of credit says if this entity ever needs to borrow money, Wyoming will provide it. In exchange for that line of credit, this entity here gives the equity stripping entity a first deed of trust for $300,000. That means when a tenant is looking at the property, it appears to be fully encumbered. The property's worth $300,000. This Wyoming LLC has a first deed of trust, first dibs of $300,000. That is a way to throw tenants and other predators off of the attack. We want to have these properties be encumbered if we can. Remember, debt is a form of asset protection. If this property is worth $300,000, there's a first deed of trust on it of $200,000, the tenant can only get $100,000. The bank has first dibs to the first $200,000. So $100,000 is exposed. Would a tenant go after that? Well, maybe not, because when you force a sale of the property, when all the fees are paid, you're not going to get $100,000, you might get $20,000, and an attorney may not want to bring that case. If there's $300,000 in equity, the attorney may look at bringing that case. So that's where we think about putting in an equity stripping scenario to throw them off the track. Again, these are all covered in my great book, Loopholes of Real Estate, but we want to form an LLC for the property we hold. We want to follow the formalities on an ongoing basis. We have that protection every year only if we follow the formalities. We want to segregate assets. We don't want too many in this one LLC. We want to use a Wyoming LLC to hold these two, because in attack number 2, the car wreck victim has to fight through Wyoming to even get to these two. And then if there's equity in these two properties, we want to use a separate Wyoming LLC for the equity stripping. So these are some of the strategies that we use at Corporate Direct. We'd be happy to talk to you further about them. Thanks very much for joining us today.